Thank you, Margaret. And some of you might know me, some of you might not. My name is Jose Antonio Rivas, and together with Ian Laird, we co-founded Washington Arbitration Week, but we really co-founded Washington Arbitration Week with the arbitration DC community 6 years ago, where we were all in the middle of the pandemic. And at the time, the arbitration community was very thirsty to go back and communicate with their colleagues. And Washington, D.C., before the pandemic, had a very sort of isolated experience. I would meet my colleagues, ironically, in the arbitration community in Miami, or I would meet them in Italy at IBA or ABA events, etc., and or at best at ICSID, but that wasn't sort of a collegial meeting. So so basically, there was some sort of disconnect. So that pandemic gave us the opportunity to sort of bring everyone together, and thanks to the trust, especially of some of the folks that are here, Marin, and others, we were able to launch Washington Arbitration Week. At the beginning, it was basically a little experiment. And then later on, it really became what it is now. I think that we've grown and we would like to grow more. And we have kept one feature, which is really important to us and some people. I remember initial talks, is it gonna be paid to speak, or is it gonna be paid to appear? And we very stubbornly said, no, it's not gonna be paid to speak. There's gonna be some sponsorship, but we do believe in a community where everyone, to the extent that they can, may contribute. And luckily, we have, yes, partners from law firms. We have counsel from law firms, and we have arbitrators and all top of the ranks. But we also have PhD students who have research on topics that have never been considered. So it's a balanced community, and I think that that's one thing that allows it to grow. The other part of Washington Arbitration Week is that it's free of cost. So, and this morning I had a conversation with sovereign state officials in Asia, and I said, well, if you cannot attend, because yes, now it's what? It's 12 or 1 p.m. So now they're sleeping, right? Well, they can see it online later on and by video. So that's part of what we're doing in Washington Arbitration Week, and we're working hard to create a video library so that people can see the videos, etc. Now, let me turn to this topic. Sovereigns settle too, do they, or not? And this is really a topic that I can see is perhaps the child of persistence, and that's why I wanted to introduce Frauke, because I happen to have the honor of being her colleague when I worked at ICSID, and since the days she was very persistently working on mediation at a time when perhaps there were less than 10 mediations successful, or 5 mediations successful, and she was like, no, we're making it. And I think that there's still a long way to go, but the fact is that there have been settlements by sovereigns, and not only necessarily in arbitration, but there have been proceedings through mediation and other dispute settlement proceedings that have allowed sovereigns to settle in investor state, but in other areas of international arbitration. So with great pleasure, I wanted to introduce her, and you may know her already, but I think it's important to know what she has done. She's a team leader on what she's doing, legal leader and legal counsel at ICSID, on one of the case management teams. She joined ICSID in September 2003. And before ICSID, she worked at the World Bank Inspection Panel in Washington, here in DC. She holds law degrees from the Freie Universität Berlin and from Georgetown University Law Center. She completed an LLM, and she has a master's degree in organizational psychology, focusing on alternative dispute resolution from the Fern Universität Hagen. And she's an accredited mediator and admitted to practice law in the state of New York and Washington, D.C. So we could say a lot more, but I think that summarizes. So Frauke, do take it away. Thank you.
Thank you, Jose Antonio. I fondly remember our days at ICSID together. And it's true, it started very early on, my interest in settlements and dispute resolution as part of ICSID's mandate to support economic development. And as the name gives away, it's the settlement of disputes. Thank you to Yams. Margaret just disappeared, I think. Over there. All credit actually goes to Margaret. Margaret had the idea of putting a panel together, and with her enthusiasm about ADR and mediation, we soon came up with a great outline for the topic and a fantastic set of speakers who I'm going to introduce to you now. We'll start with Lorraine, who is on the screen. Lorraine is a distinguished dispute resolution expert with extensive experience in complex commercial litigation, arbitration, and mediation across both domestic and international arenas. Lorraine holds leadership roles in key legal organizations and was appointed by the US State Department to the NAFTA 2022 Advisory Committee on Private Commercial Disputes. Before I turn to the next speaker, I should tell you that it took me 3 tries to shorten the bios for this panel. If you go online, you will see much more background and achievements and accolades that they share. Next to me, I have the pleasure of having Ximena Bustamante, who is a leading mediator in Ecuador. She handles complex disputes, including those with the state of Ecuador and public entities. Ximena has held prominent roles in both national and international mediation initiatives, including serving as National Director of Mediation at the Attorney General's Office. And I'm especially grateful for her to coming here today because she will share some insights into state organization that I think is crucial for settlement in the investment context. A senior fellow of the Weinstein International Foundation, she also teaches and has trained mediators across Latin America and the United States. We turn back to the screen. Bill Marsh is one of the UK's most experienced mediators with full-time practice in mediation for a few decades, and international recognition as Mediator of the Year by Who is Who Legal in multiple years. He has successfully mediated a wide range of complex disputes in various industry sectors involving parties from over 25 countries across various continents, including governments, corporations, and public bodies. Bill has also acted as mediation advisor to a number of governments. So Ximena and Bill have had multiple investment mediation experiences, and they will share insights, which is the segue to Joe, who I had the pleasure of assisting in an ICSID conciliation, and I know Joe has also done an investment mediation. Joe is highly respected international dispute resolution lawyer with experience across more than 65 jurisdictions. He has served as counsel, arbitrator, mediator, and conciliator in hundreds of cases across industries and applicable rules. And last but not least, our local warrior, Jonathan Hamilton, who is a globally recognized international arbitration expert and co-chair of his firm's arbitration practice. Jonathan has led teams to resolve high-stakes disputes and negotiations spanning across 5 continents and many industries, including investor-state and commercial cases. Jonathan is a supporter of WA and brings a multidisciplinary background to his work in law, policy, and public affairs. So you see, we have really a wealth of information and practical insights on the panel. And I'll briefly introduce the topic that we have today. Bear with me. I just find the Zoom share and we're off to go. It should be the slide now on the screen. So Jose Antonio pointed to it. Yes. These are the outcomes in ICSID cases. We publish this twice a year. This is one of the many aspects that brought us to proposing to ICSID's member state a set of mediation rules. What you see in yellow is 34% of cases discontinue and settle. When you break this down annually, this is a consistent percentage. 2 years ago, it actually went up to 50%. So that was an indicator that even at the arbitration stage, there is room for settlement in investment disputes. I should add at this outset that my colleagues from the World Bank have identified that only 6% of investment disputes actually end up in arbitration. So 94% are not at ICSID and not in arbitration. And so there is a lot of settlement opportunity for economic development. Ooh. Hold on. I cannot move the slides. Good, then we'll do it without. So 2 years ago, we proposed to our members, 3 years ago, our mediation rules in 2022, which allow the Secretariat to administer mediations that relate to an investment, involve a state or an REIO, and which the parties consent in writing to submit to ICSID. So you're not reading it on the screen, but when you hear it, you realize there is no link to ICSID membership and there's no nationality requirement either. So we wanted to make it broad for states to agree to mediation of any disputed issues that they may have. A feature of the mediation rules that is little known is that you do not need to come with a pre-existing consent. If you'd like to mediate your dispute, you can file a request for mediation that contains an offer to mediate, which the ICSID Secretariat will then transmit to the other side, inviting that side to state whether it accepts the offer to mediate. If we don't hear anything, or if the offer is rejected within 60 days, we will not take any action. This was introduced especially at a request of states to include ICSID, a neutral forum, in the resolution by mediation. We've published background papers if you want to hear and read about practice, the ICSID background paper on investment mediation and an analysis of mediation provisions in treaties. And now we will pull up one more slide, which provides the overview of a mediation process, which we thought at the outset we would share so that we give some insights for those of you who have not participated in a mediation at this stage. Why is this still coming up? Is Maria here? Okay. We have a process overview that identifies a mediation that at the outset, you have a stage where you organize the structure and structure the process. The mediator is appointed, and then the mediator will engage with the parties about gaining clarity. That is the first step of the mediation, identifying with each party the disputed issues, the views of the party on these issues, and exploring why the party holds these views. On the basis of that, possible solutions will be developed with the mediator. And Maria, maybe you can help us pull up the slide. Yes. I did the share, but nothing is happening. And on that basis, then possible solutions identified on the basis of the priorities of each party. These can be economic priorities, these can be political priorities, these can be financial or economic, environmental priorities. And really, it's about wise solution finding. And if settlement is not in the interest of a party, then that is a fine outcome in mediation as well. So it is important to identify at the outset that mediation doesn't require anybody to settle. What it is meant to be is a process to make good solutions for a party in line in what the party wishes to reach. So with that, we're going over, while we're fixing our technology, we'll start off with Bill. Bill, you have mediated a number of investment disputes, and can you start off with an overview of practice, maybe looking at these stages that I outlined before?
Yeah, thank you, Frauke, and thank you everybody for being here. I'm very sorry I can't be with you in person. I've been given 4 minutes to give you an outline of the entire IS mediation process. Let me start by saying it's an incredibly valuable forum, particularly for states. I don't think states find it that easy to create fora in which talks can meaningfully take place. So it's an extraordinarily valuable one, and therefore important to think how one might use it. Secondly, I should say that what I've got to say is not, you may or may not find in the literature, I don't know. I'm simply talking about the product of my own experience and what I've learned, as it were, along the way. Let me start with the sort of preparation and setup phase that Frauke referred to a moment ago, because I think this is particularly important in IS mediation. It's quite obvious, I guess, that you can't simply wander into talks with a sovereign state without a fairly serious amount of setup. And so getting that part right is very important. I think it's also important because sometimes states can feel an apparent loss of power by the appointment of a mediator. And it's therefore absolutely critical that states in particular, all the parties, but I think states are more sensitive to it, understand how they can best work with a mediator. The kind of issues that come up would be, for example, who's present, who has meaningful authority, who can really take decisions, what are the optics of who attends. Self-evidently, it can be, parties I find quite sensitive to the optics of whether they're sending people who are more senior or less senior and so on. What's the legal status of the discussions that are taking place? I think here I found a particular sensitivity on the part of states to know that the governing law of the mediation is their own national law to the extent they have a law on mediation. So that's an unusual wrinkle, perhaps, from the normal commercial mediation. Critically, I think, how will settlements be signed off? And I know that would happen at the end, but in fact, addressing this point at the beginning, I find to be immensely important. If I think of one of the most recent ones I did, the state sent to the mediation was a negotiating team with reasonable levels of authority, but after each meeting, and certainly when a deal was on the table, they had then to discuss it with a committee above them. It then had to go from them to the cabinet, and it then had to go from the cabinet to the National Administrative Court for approval. Now, you can imagine if that process is only mentioned by the state at the end of the talks, then in this case, the investors with whom they're dealing are going to be pretty unimpressed. So dealing with these kind of realities in advance is critical. In terms of the content, and looking at my watch, barely got past the first point. I mean, Frauke is right. I think the starting point for discussions like this is never agreement and is almost always clarity. What are the issues? And crucially, why do people hold those views? That's partly a product of legal analysis. But in the investor-state mediations that I've done, often it's other priorities that come to the fore: economic priorities, environmental governance questions, political questions, pressures from affected communities. I'm involved in one where the community surrounding a mining site is at times very violent. So that the government is extremely sensitive to the views of that community and their protests over pollution. So clarity is part of it. I think risk is part of it. There needs to be meaningful dialogue, at least within each party, and sometimes between the parties. I can see Frauke's waving a bit of paper, so I'll close down at this stage. There needs to be some meaningful discussion about risk. And ultimately, you need to get into some meaningful negotiations. I'll say one tiny point about negotiations. States don't have self-evidently the freedom of movement in the same way that commercial entities have. And therefore, it is critical that offers are rationalized and presented in a way that is not just an actual or perceived carve-up, but can be susceptible to audit trails and other due processes to rationalize them.
Thank you, Bill. And I especially find this point very important. It's not that mediation is in a vacuum and doesn't consider the realities of having a settlement set up. So I am German. In Germany, soccer is not only the national sport, but an identity. And so I brought yellow and red cards for my fellow panelists, and it goes right over to Joe, who I know likes football as well. And Joe, as your experience as a mediator in investment dispute and as having participated in many mediations, but also arbitrations, can you share with us what's different from being an arbitration counsel? What's effective? What's helpful in mediation?
Well, good afternoon, everyone. It's great to be back here in very warm Washington, DC, certainly a lot warmer than London that I left very much in that autumn there. I will try and respect and avoid the time and avoid the red card. I think you won't be surprised to hear, having been counsel for the best part of 35 years, most of my day job mainly these days is arbitrator and mediator, but I think the role of counsel is crucial. And I say that not just as a self-serving comment, but I think you just step back, particularly in investor-state mediation, because they're essentially the gatekeepers. They're the gatekeepers to the process in terms of identifying the process. Very few people really even know investor-state mediation exists. I mean, it's a hard enough sell with commercial mediation, we all know, but investor-state mediation is something else. And so I think it's very often the lawyers themselves who have the ability to present an alternative way of going forward. And in order to do that, they need to obviously inform themselves. So being aware of the nuances and the differences, just as with commercial mediation, it certainly applies to investor-state mediation, but it has obviously its idiosyncrasies as well that one has to factor in. But they're also another gatekeeper in terms of identifying potential mediators, because at the end of the day, mediators, whether in any form, is really crucial. And so that's, again, being able to know who is good, who has the experience, because I think there's always that danger of just saying arbitration is a form of litigation by another name, and mediation, we can all do that as well. And yes, of course, I think one can be led to have that false sense of security or awareness, because there is so much that overlaps, but there are some really fundamental differences. And I think being aware of that is very crucial. I just wanted to pick up on something that Bill said right at the very beginning, because while governments, it is in their interest, I think he was saying, to look at this as an alternative way of resolving things. It is also for investors. In my personal experience, very few investors, most investors are extremely reluctant to sue and litigate against the state. And often they will go for years, quite literally, negotiating with different and get really frustrated. And ultimately, it's the kind of nuclear option they go there. So I think being aware of different mechanisms is really important. And with this, I just conclude that none of this is really new as well. It always, in fact, you were the one reminded me of this some time ago, Frauke, that, I mean, ICSID, the dispute resolution mechanism of choice, is actually conciliation, which still exists. It's hardly used. I think there's something like 18 cases now in the 60-odd year history of ICSID. So it's not a new concept. I mean, it's now changed with mediation, and there's been great work that's been done by organizations such as ICSID, UNCITRAL, and others to kind of push things forward and to pick up. And I think COVID certainly also had its impact, opening people's minds to wanting to do things slightly differently. So I don't know, I must be close to the 4 minutes. So it's just, in a nutshell, I would say it's fundamental, the role of counsel, but it is different. And I think that is really the key message. And I think anybody who thinks, well, I can have a go at doing it, probably can, but whether you do it well or not is another story.
And I think it is clear that in mediation, we are not arguing about whether there is a breach or not as the only. The law is certainly a very important aspect of it, but as the slide points out, it's a much broader consideration. Ximena, what are hesitations of governments that you have seen to mediate, and why do they then choose to mediate? And we already touched a little bit upon it. What are organizational aspects to consider, and how do you decide as a government if you want to mediate? I know that's a lot for your time slot, but I know you know all of it from practice.
Thank you so much, Frauke, and thank you so much for having me here today. I'm deeply honored, Jose Antonio, Margaret, for everything you've done and put together, and Frauke. And I know I'm taking time from my answer, but this is, I think, is a very interesting question, long question, so I'll try to be very fast. But I think it depends on the government's prior experience that it has had with mediation. But in my practice, I think that the hesitation to mediate is surprisingly why they choose to mediate in the first place also, and that's ownership over the resolution and control over the resolution. So as you know, hesitations, mediation with the government includes or requires to include several officials, as Bill was mentioning, that sometimes don't have enough authority, that don't share the same criteria, and who need to participate in the decision-making process. So that in itself is already very challenging. But to add to that mix, the fact that each government official might be personally liable for his or her participation in the decision, that brings a whole different level of complexity. And so how do you bring them to mediate? I think that is exactly what Bill was saying. Mediation provides an adequate space for the government to explore possible solutions that might be better for it in terms of costs and contingencies. And that exploration space needs to be a safe and adequate space. So as you know, mediation is usually protected by the law. So any exploration, concern, or proposal that comes into the table is made without prejudice. So the government officials won't be getting any new liabilities from proposing ideas or coming up with things. And so if there is no settlement, nothing has happened. There is nothing to lose, instead a lot to gain. But if the settlement is reached, then that settlement needs to be grounded on the facts and the law and be with all the protections so the public functionaries won't be getting any new liabilities, and maybe even control those that were already derived from the conflict when it began. So, but of course, for a government to have this, you need institutional framework. And I feel the essential one is that you need to have a legal provision that authorizes the state to sit in a mediation, especially in civil law countries where, you know, the government cannot do anything that is not expressly permitted. You need a law that says, you know, you are expressly permitted to go. There are jurisdictions that have the opposite regulations, so then it's no possibility. But then you need mediators, as Joe was mentioning. You need very skilled mediators that are very proactive into bringing the necessary public officers into the table at the right timing. So it's what Bill was saying, you know, you cannot just get a full day mediation and settle at the end of the day. It's a process that might take some time. And the mediator needs to be very consistent and even a little bit stubborn to keep pushing people into, you know, the right direction so that the settlement can actually happen. I think that you need a mediated settlement agreement that will provide enough protections. And I think it would be fantastic if the government as a policy would desensitize governmental inaction, because it's easier and safer sometimes for public officers to just not do anything and let judge or an arbitrator decide. But if as a public policy that's desensitized, then it might be better for mediation. But even with some of that, or even without any of it, or at least just the law, I think that the process in itself brings a lot of benefits. I know we're going to hear a little bit more about it, but at the very least, let's party gather information that maybe cannot get otherwise. And that mediation, since it's a forward-looking process rather than focusing on assigning blame, it enables both sides to reach resolutions that can restore an investor-state relation or bring new investments and ultimately get, you know, to satisfy their real interests. And of course, compared to arbitration, it will save costs, time, reduce uncertainty, and even prevent reputational impact that often result from international investor-state arbitration. So I hope I did it in time.
Fantastic. Oftentimes,
May I just abuse 30 seconds just to show how the world has changed? In fact, far from where officials have gone for decades just sticking their head in the ground and not wanting to take responsibility, there's a real risk, and I know a real story of where officials are now sitting in prison because they didn't consider mediation. And it was part, I mean, there are wider allegations of corruption, arguably, but one of this was that they allowed a dispute to run on for years and cost the state millions of pounds. And this is something that's come back to bite them several years later. So just an interesting
thank you.
example
Thank
of-
you, Joe. And I think oftentimes there's a question, and we'll touch upon that in a little while, about what is actually the benefit of mediation when you can have direct negotiation. And I think you hear it from Joe's contribution and Ximena and Bill. The mediator has an ability of talking to the parties and exploring different, challenging the parties perhaps on different grounds, like, okay, if you agree to this, how would that look like? What would happen afterwards? And assisting the parties in working through especially those concerns of liability. You also brought up the anchoring of mediation in national legal frameworks or international treaties. And this is why we did the treaty analysis, but certainly mediation is also an option in contracts. And the negotiation and settlement authority is something that we also picked up in the ICSID rules, and that at the first session you need to identify that in order to really link the negotiation with the final outcomes. And the mediator has helped in mediations that I have seen really to get that clarity into the room and create the trust. Lorraine, thank you for waiting patiently online. Over to you. What does mediation really provide that arbitration does not? Can you tell us a little bit briefly about the historic developments of arbitration and mediation in the international context?
You're muted.
I think you're muted.
Oh.
Are we muted?
Lorraine, if you can hear me, I think you are muted.
Okay, sorry about that.
Problem?
I think one of the biggest selling points of mediation is confidentiality. And this might be a topic for the panel to get into. If ICSID is doing mediations and ICSID arbitration cases are public, how are they going to deal with that confidentiality aspect? So that's one thing I just throw out there as being a sticking point. The other thing about mediation is it allows the mediator to come up with a creative solution that isn't necessarily within, the strict confines of the governing law. And that has been a boon for me in settling mediations, because I can offer things or suggest things that that'll put the mediation over the edge and the parties will settle. So that's something, again, that's not available in arbitration. As for the development, and just one more thing, Northern Ireland is a good example of a dispute, if you want to call it that. We call it the Troubles, something that nobody thought could be settled. And George Mitchell, by seeing the parties separately only, they were never in the same room, managed to reach a solution to the Troubles in Northern Ireland that's been a lasting one until now. So that to me was an incredible use of, shuttle diplomacy, mediation. And, that's the type of, the parties aren't going to arbitrate something like that. So I think mediation can be used in so many different ways. Now, as for the development that I've seen, when I initially started work with the ICC, the rules were called the conciliation and arbitration rules. Why is that? Well, you didn't have a New York Convention on arbitral awards until 1958. So it was difficult to enforce mediation, arbitration awards. But what happened is in 1958, with the New York Convention, and now there are almost every modern country is a signatory to the New York Convention, you had a vehicle where enforcement became possible. Now, again, when I was at ICC, I was on the working committee for the ADR rules. And Frauke, I don't mean to insult your country, but the German National Committee called them the alarmingly decreasing revenue rules because they were worried that mediation would take away a lot of revenue from arbitration. And I think quite to the contrary, that has not been the case. First of all, not all mediations are successful, but when you can provide your client with a cheaper, faster, successful alternative, they're going to come back to you for arbitrations or for things that can't be decided within mediation. So since 2004, the other thing that we did, and this was David Plant, who's no longer with us, but a very well-known mediator in the United States. David and I pitched the idea to Anne-Marie Weissel about doing a mediation competition in Paris. And the idea behind that was to raise awareness of the ADR rules. And now it's one of their most successful, I think it is their most successful competition. And now you have all these young people learning about ADR and mediation and other forms of ADR in law school. And so, that's not something I learned in law school. It was always arbitration. So that's gone a long way to advancing, and debunking the mystique that mediation is not something that the parties want to do. So in the 21 years since the ADR rules have been in effect, you've seen a large uptick in mediations. And in my view, as someone who arbitrates and mediates and has been counsel, for mediations and arbitrations, I see that as a very good thing. And I believe the growth in mediation will continue. And if mediation turns into arbitration, which I heard someone mentioning terms of reference for mediations, and I just had a chill in my body. I said, then there's going to be some other vehicle developed because clients want it and they're using it and they're saving money and they're saving time and they're keeping privacy. If you go to enforce an arbitral award at court, that award is then public. Now, that is a small percentage of arbitral awards, about 10% go to the court for enforcement, but nevertheless, it's still, you run the risk of it becoming public at that point. Whereas with mediation, that's not the same thing. So I'll stop. I think I've used up my 4 minutes.
Thank you, Lorraine. Just confidentiality came up, so maybe we take a moment, a note on this. Confidentiality in the investor state context might have a slightly different connotation than in purely commercial. Under the ICSID rules, the starting point is information is confidential unless parties agree otherwise. Disclosure is required by law, or a document or information is independently available. You cannot cloak something that is already out there. That's the idea. ICSID does not publish information about the mediation without consent of the parties. So that's where it's different. If we look at the practice, and Ximena and Bill and Joe touched upon that already, is that settlements in the investment context, be it with or without mediation, are not necessarily agreements. They may take the form of a decree or of a law, including like one famous case, Vattenfall versus Germany, where nuclear power ending would required the adoption of a law, and may come as at peculiar times. This was published right before Angela Merkel left office. So these are all considerations that we may hear about too. Lorraine, you wanted to add something?
No, I'm just curious because ICSID, like the Iran U.S. Claims Tribunal, being a public arena where the decisions were published, how do you get around the aspect of ICSID being open to the public and yet keeping the mediation completely confidential? That seems kind of a contradiction to me.
We discussed this especially at length with our member state. It was very interesting. When you look at our working papers, the confidentiality provision looks slightly different at the beginning. What we decided is that this is a policy matter for the states to decide. If you look at, for example, the EU treaties, the EU FTAs have confidentiality provisions that require, for example, the settlement to be made publicly available with redacted form. So we wanted to leave that for the parties to agree, and Ximena and Bill may be able to provide other examples from practice of audit, government accountability office, or approval by a court. Jonathan, thank you for your patience. Over to you. How does a council create conditions for resolution while still representing a party, be it in an arbitration or otherwise, and sovereign or an investor? What are benefits for council to mediate, negotiate?
Artificial intelligence or an algorithm cannot carry out the elements required to reach a settlement through a negotiation in an investor state scenario. Now, I could lightly say that the elements required to reach a settlement include things like patience, food, football, occasional whiskey, and even flowers. I once received anonymous flowers at my office, and I thought, okay, what are these anonymous flowers? And I got a call the day after Christmas from the in-house counsel of the investor on the other side of the matter and said, we wanted to know how you liked your flowers. You complained during the negotiations that we had never bothered to give you flowers or do anything nice for your side. So we decided to send flowers. So there are many things that are involved, and I want to highlight a few things seriously in particular. I went to Peru when I was still a law student and worked at a firm there, Estudio Checopar, and I met a very well-known contracts professor, Manuel de la Puente y Label. May he rest in peace. And he told me, Jonathan, to understand foreign investment, you need to understand la ley Bariñas. And so, of course, I set out on a mission to understand la ley Bariñas. And I found that there was an investor-state arbitration at this point about a century ago that had been established on an ad hoc basis at a time where there was no framework for resolving disputes. And then again, in the late 1960s, there was another dispute related to La Bariñas, which is an oil field. And the government reached a settlement with the foreign investor, but it was carried out in a non-transparent manner that, when revealed, basically led to the fall of the democratically elected government. So you've got to know your terrain. The existence of arbitration waiting in the wings is critical to your ability to negotiate so that everyone understands where the chess pieces are positioned. And I'll tick off a few examples of cases that have been resolved before, during, and after arbitration. So understanding what could happen, what the negative scenarios are for each side is fundamentally important. And you also have to know your terrain by understanding, just like a government doesn't pick its geography on the planet, you as counsel do not pick the political geography or the commercial geography or the human terrain that you are coming into. And you've got to fundamentally understand where do you stand and how can you get close enough to where each side wishes they could go to try to reach commonality. And to do that, you have to also take into account that on each side, there are many different points of view. This is certainly the case with multinational companies, but it is definitely the case with governments. In the class that I teach on complex negotiations at the University of Miami, the students go through a negotiation exercise and they each form teams, the state team, the investor team, the lender team, the community impact team, and they each have confidential missions that they're supposed to be carrying out. And the students are always surprised at the end of the exercise to understand that on the sovereign team, the president's mission is she'll take a win if she can get it, but above all, she doesn't want a loss. The Minister of Economy's secret mission is to achieve a successful settlement because He wants to run for president and claim this as a victory. The Minister of Environment's mission is not to protect the environment. It's to make sure that the Minister of Economy doesn't succeed because the Minister of Environment wants to run for president. So you come into these situations and you have to be able to understand and ascertain what's going on within the sovereign and how you can partner with the right people to find a solution. I once was in a negotiation where the state side brought about 30 people to the room. And I realized that the person whispering in the ear of the minister who had the least fancy title was the best person to target to try to find common ground. So bottom line, transparency, simplicity, being willing to call a tomato, win-win, and managing timing. And my quick tick list of examples where these approaches have made a big difference. The Panama Canal expansion project, we negotiated an interim resolution prior to arbitration so that the project could continue to stem the losses, maximize the success of the project, and agree to disagree another day in arbitration. On a major airport infrastructure project, arbitration was commenced, then discontinued. The parties formed a new model for describing the project, a strategic alliance that facilitated the continuation of a project that the arbitration would have been in excess of $2 billion in damages. The Abaclat case, last example, Abaclat case.
I hold you to it.
Abaclat case related to sovereign bonds. We achieved a jurisdictional victory in the arbitration that created significant pressure. And we had the patience to wait for a change in government that changed the conditions for success and achieved a $1.3 billion settlement. So those are a few snapshots of the way that using flexibility and respect for the other side are really the critical elements as counsel to getting something done.
Thank you, Jonathan. That's a good segue over to our next round of questions, which we will hear from Ximena and Bill, that really in mediation, as Jonathan already touched upon, there is a mediation between the disputing party and there is a mediation going on perhaps within one party to aligning different ministries, different interests, different goals within a settlement. And we get to that. But first, Joe, let's look at the practice. Jonathan alluded to it. Look at timing. And how do you look at mediation, arbitration? What are models to combine the two? Are there?
Well, I think timing is, I think it goes without saying that the sooner one engages in these processes, the more likelihood you're going to get the maximum benefit in terms of saving time and cost. But often it may well take a lot longer, a bit of pain that has to go through for the parties to be able to take it seriously, to even contemplate it. But I think you might be alluding to MedArb, that one hears a lot about combining mediation with arbitration. And interestingly, there are kind of two types of MedArb. I suppose there's one where the mediator, you have the simpler, less controversial one is where you have the arbitrator is separate from the mediator, and it may run in parallel. The mediation may run in parallel to the arbitration, or you may stay the arbitration to allow the mediation to be explored by a different mediator. Whether you have a lot more controversy, and this is where you have the same person wearing both hats, both as an arbitrator and then a mediator. And I think the consensus seems to be on the whole that you just don't do that. Having said that, there are important parts of the world where it's totally acceptable and been done for thousands of years. China is the obvious example, I think, where they seem to be quite content for somebody that they consider generally a senior person, but that person to make a decision. And so I think there's it's an interesting difference. In Europe, I believe in Germany, they're a little bit more sympathetic to it, and in Switzerland, but basically pretty much everywhere else. So this is not a kind of East-West common law, civil law divide. Generally seems to accept that that should be separate. And so I think in that regard, so if I'm, as counsel, would certainly be avoiding trying to, if MEDA was to come up, but I definitely think it is something that needs to be out there and viewed in this holistic view of an additional tool in our toolbox as dispute resolvers, because all too often we end up, and we like putting ourselves in these pigeonholes of litigators, arbitrators, mediators, and that none of this ever really interacts. And I think in reality, what clients expect, increasingly so sophisticated clients expect an appreciation and an understanding of dealing with all of these concepts at one time, and understanding, as I said right at the very beginning, the different nuances and they are different processes, and you need different skills for them to work. So, but it's all about trust. And I think the interesting thing about clients, I mean, there is a real tension as counsel that you can oversell it. If you sell it too soon, clients may not think that you have the focus and the strength to see through with the client. So I think that there's a real diplomatic balancing act one has to do in terms of presenting it to a client convincingly. But of course, if you have the trust with the client, ultimately, they 9 out of 10 times will work with you.
And look at timing. Like in the olden days, mediation was often thought about only as like a mechanism in the cooling off period. And I think of the examples that Joe and Jonathan gave, and we hear from Ximena and Bill, mediation is a possibility at any time when the parties consider that settlement might be what they want to have. And we have numerous cases at ICSID where at the outset you wouldn't have thought that they settle. Jonathan gave a couple, certainly the Abaklat, when that was first registered. I'm not sure that we thought this would settle, but it did. And so there are others, and in the policy, we have a couple of states that offer mediation in their policy at any point in time.
It's also just worth flagging, I think, that it's not a one-stop shop. You don't try mediation. If it doesn't succeed, that's it. I mean, it's something you keep under review, and you may have several attempts at mediation.
And you may come back later, exactly. Just a note on what you were just describing, Joe. In the ICSID arbitration mediation framework, the default rule is that the mediator and arbitrator cannot be in the same role unless the parties agree otherwise. Of course, that is in the parties' hands. But Jonathan, over to you. What are concerns you have encountered in your practice about investment mediation, using a process rather than direct mediation? 4 minutes to you.
It is very important, of course, to be a tough warrior for your client, but arrogance and disrespect are weak. And even more critically so, can be highly damaging to your client. And I think that's especially so for investors who tend to have more capacity.
Does anybody speak English here? Yes.
All right. Especially so in the case of the conduct of investors. There's a concept in treaty arbitration of non-aggravation. And so when we see investors carrying out harassments, creating fake protest groups, social media manipulation, and yes, waking me up in the morning with Twitter blast against me and things like that I've seen as well, that is not impressive. You're not impressing a president, a minister, or anyone else. It's weak. And so in the mediation context, when you take the approach of arrogance and disrespect, you basically amputate the capacity of a state to agree to negotiate and mediate with you. It's simply not impressive. Be tough, yes. Be grossly disrespectful, no. Now, in terms of the particulars of using a mediation procedure, I have to express, and Ximena may have comments to the contrary, but there are state mandated or offered mediation processes. Ecuador is one jurisdiction that offers that. That tends to raise an eyebrow for investors in particular, because the general feeling is that the odds of having a neutral procedure managed through a state organized entity is not going to be neutral, or maybe a vehicle basically to gather information and sort of carry out discovery before you enter into an arbitration. So I found that to be very challenging to reach significant outcomes. And then finally, I think understanding that carrying out a mediation is still subject to all the best practices that I mentioned. And what I mean by that is you still have to take into account that ultimately what the state does must be transparent, must reflect compliance with law, and fundamentally the timing is critical. So timing relates to market factors, commercial factors, what's happening with respect to a particular investment, and critically to political cycles. And you've got to respect that having a mediation that is ill-timed around political cycles may not have a chance at success, and you've got to be prudent about timing. Thank you.
Thank you, Jonathan. And that gives us over to Bill. Bill, what can a mediator in an investment dispute do to navigate concerns about process and settlement, timing, or personal liability? We talked about buy-in from political forces other than those that are sitting perhaps around the table. And of course, broadening the acceptance and sign-off on any settlement that might be reached.
Yeah, thank you. So many questions in there. I should say at the outset that I think Jonathan must have got hold of my notes somehow, because we got so many comparable points that I also wanted to cover off. So genuinely thank you for raising them. I mean, I think for me the starting point is that investor-state mediation is not easy. That shouldn't surprise us. Probably no mediations, no challenge. Mediations of difficult cases are not easy. Full stop. So it's no good coming into it thinking it ought to go smoothly. And it's no good the parties thinking that mediators in some way are magicians. And as Jonathan said, if one party wants to destroy their own or attempt to destroy somebody else's credibility by being abusive and arrogant, they may well go ahead and do that. It's a pretty foolish thing to do, but there's only a certain amount you can stop. I think it's also true that what goes on in a mediation is usually a relatively small part, in a way, of the bigger ecosystem within which that dispute is being carried out. And I reckon as a mediator, if you know, I don't know, 25% of what's really going on, you're not doing badly, because that's just the reality of life and of being involved in complex mediations. But if I touch quickly on the personal liability, I mean, I think it's true that the role of representing any party in a mediation, particularly a state, comes with quite a lot of pressure and the opportunity to be highly criticized subsequently for what you do. That said, plenty of IS mediations settle, so clearly it's not impossible. I think I touched on it earlier, but for me, the process of a clear rationale for a settlement is so critical. And I think often each party feels that it's the other party's responsibility to come up with their own rationale, where in fact, if you're an offering party, let's say, for example, you're an offering investor, you can attach to your own offer a perfectly sensible rationale that has some chance of landing well with the state representative. So I think parties have more agency in how they construct these things than they may instinctively feel. I have come across one case in 35 years of mediating, including investor-state cases, of outright fear and refusal. Somebody said to me, a state representative said to me, if I agree this, then I fear for my and my family's safety, and I certainly am pretty convinced that neither I nor my family will work again in our own country. And so his request to me was, because he saw the logic of agreeing the settlement terms that were on the table, his request to me was, would I somehow recommend or endorse them? I said I wasn't able to do that, but what I was able to do was commit to writing that the terms reached were A, the product of serious negotiations and a perfectly coherent process, which I think was helpful. And B, was that on their face, those terms appeared to be informed reflection of the risks that the parties were telling me that they and the others faced, caveated, of course, by my role. Now, in that particular case, that was plenty for this guy. He took that with both hands, went home happily. agreement was, the terms were approved, and off you went. So it may be, and I stress may, be that there are certain lengths to which mediators can go to enable that. I suppose the other point really is timing. I have a real concern actually about mediations that arrive at mediation under contractual provisions, because those contractual provisions will have been arrived at by definition when the contract was entered into. They may or may not bear any relation to the context that the parties then find themselves in at the time of the dispute. So I think those contractual provisions are good for raising the topic. I do get concerned when parties feel bounced into mediation, when on their own analysis, they're simply not ready for talks, because either they don't understand the position, or they haven't seen enough evidence, or they want to fight for a while, or it's not, the timing is not politically right, or whatever it is. So I think there's a call for some flexibility and thoughtfulness when it comes to that. I think the other point is about addressing these things up front. And there's a difficult balance there with addressing who attends and how much authority they have. So for example, if at the outset of a mediation, let's say you're an investor, for example, and you require a certain level of attendance from the state in order to go ahead with the mediation, you may well not get that at that stage and therefore jeopardize the mediation. That may be a good call or not. If, on the other hand, when you're already making progress in the mediation, you then seek to escalate the seniority, because you've got something to build on, you're in a much better place to do it. So all these points argue really for thoughtfulness and flexibility in the process.
And this is one benefit of the mediator, certainly too. Early on, as you outlined, this is articulated and addressed with the parties, and can help design a process, or unilateral withdrawal in a mediation is possible at any time. So, Ximena, any additional thoughts and insights from your government and mediator work in the AG's office and beyond?
Thank you. Yes, and thank you for the. Oh wait. I am having.
That allows me
Yeah.
to say that we started a few minutes late, I believe 8 to 9. So we have a couple more minutes for our panel and for Q&A as well.
Yeah. Thank you so much for the question, Frauke. I think it's very important, and I'm very happy to be able to share with the audience, I think, the remarkable experience that Ecuador had in mediating with cases involving the state. So just to give you a bit of context, I've been obsessed with mediation since the beginning of my professional life, and I just love this idea of helping people settle. And of course, being Ecuador, I was interested in promoting investor-state mediation and getting those cases also into the mediation table. Of course, every professional that used to talk to me would say, that's extremely difficult, doesn't happen, it won't happen ever. And these cases simply cannot be mediated. Fortunately, I think Ecuador has proven the opposite. So in 1997, the Attorney General's office established a mediation center. I think that's what Jonathan was referring to. It was established for handling private disputes at the very beginning, so it wasn't a big thing. But by 2013, it had already received about 400 mediations that involved a public entity or a governmental agency. Today, it handles about 1,000 mediations every year that involve a public entity or a governmental agency. Considering that mediation in Ecuador is voluntary, the fact that the private parties, because they are the ones who look for this mediation at the Attorney General's office, the fact that they go, I think shows the trust and the credibility that that office has gained over the years, and that it is efficient in resolving complex disputes where the state is involved. I think that Ecuador's success has a lot to do with, of course, I mentioned at the beginning, the legal framework that authorized the state to participate, but also, as Bill was mentioning, the rationale of the settlement. So mediation provides the space for exploration, but then once the public functionaries are ready to endorse a settlement, a specific settlement, we do look for the rationale. So they do have to write a technical report that states the facts, a legal report that says, the agreement is convenient for the public interest, the agreement is under the law, it makes sense, it resolves the dispute, and a budgetary allocation of money for whatever payment it has to be. And the settlement agreement has the same force as a judgment of last instance and is res judicata. So that settlement is like they went to the court and the whole thing happened. So through the system, just to give you an idea of what happened, I think we've been able to have very tangible results, including we've been able to review and correct miscalculated fines in public procurement cases. We've been able to reduce administrative fines using civil law principles like that of the default cures default, which is very weird in the public law, but it did work. The state has agreed to revoke a declaration of unilateral termination of contract, allowing the contract to come back to life and giving the contractor or the investor a second chance to perform. We've been able to prevent bankruptcies from companies that have been declared as defaulting and they cannot contract with the state anymore. And that if that's their main area of business, to not being able to contract with the state would have been a bankruptcy. So we rescued it. Mediation has helped the state fulfill obligations that were unclear, overcoming obstacles that had appeared in the middle of the fulfillment. And we've been able to get the state to change, you mentioned, revise laws and regulations that could have affected whole industries. So it's just a matter of giving a right space for dialogue. And I agree with Jonathan, mediator needs to be a trustworthy person for both sides, both the public and the private. And if the mediator doesn't have that trust from both sides, may not be that efficient. So I think for the Attorney General's office, it's just that the public functionaries feel more comfortable, but those mediators are very clear that they are to be neutral and they are to be independent. So they don't go around telling what the investor says. And I usually don't ask for people to bring me documents, so I'm not going to be giving it to the other side. And then it's also true that in Ecuador, it's not only the Attorney General's office that do these mediations. I'm right now in private practice and I do keep doing these mediations in a private center. So the investors are very welcome to come and look for other mediation centers also. But it's just that this has been proven by practice. We've been able to create and design the process that now for public functionaries is just very comfortable. And they like mediation and they come to mediation as a matter of policy and they are seeking, and I now have cases in which the public is trying to get a settlement and the private is being very reluctant. So it's just changed the whole view at the very beginning. It was the other way around, so yeah.
And it's not only domestic, but international.
Of course.
We compared notes. So clients that we see at ICSID have mediated in Ecuador.
Oh, really? Cool.
So Lorraine, over to you for the last contribution of our second round of questions. Drawing from your NAFTA Commission experience, how can mediation fill gaps? Is it possibly an appropriate resolution mechanism for SMEs?
Okay, well, under the NAFTA treaty, which became the USMCA, ICSID is the settlement mechanism for NAFTA cases. Now, what we did on this committee, our goal and our mission was to educate people in the North America, and by that I'm talking about Canada, Mexico, and the US, even though I know that a lot of you learned that a lot of the Caribbean islands are part of North America. That's not what we learned in school, but nevertheless, we traveled from country to country. We typically had 2 meetings a year. And what we realized was it was almost impossible for the SMEs, the small and medium enterprises, to effectively engage in dispute resolution at ICSID. It was cost prohibitive. The notion of them traveling to Washington to have their case heard, a lot of reasons made it unattractive for these small and medium enterprises. So 2 of the committee members, actually one was not a committee member, but Colin Rule, who you all know from the online dispute world, and Dana Haviland, a former arbitration partner at Wilson Sonsini, created an amazing online website in all 3 NAFTA languages where the parties could come and mediate these disputes. I mean, it was way ahead of its time and very state of the art at the time. And the governments panicked because it was ODR, the company that worked on it, was a public company, and the government couldn't really have that. And so, unfortunately, all that great work went to waste. But I still believe for SMEs, mediation is a great vehicle to resolve their disputes. It's faster, it's cheaper. It's not that hard to find somebody that speaks Spanish or French if you're dealing with Quebec. So, that's the hope that well, to be honest, I don't know what's happening with USMCA right now. The head of our committee got fired at the State Department summarily, as have a lot of people from states. So we're kind of in limbo right now, but I hope we get our committee back and running again and can continue these initiatives where we make it easier for the big players. They know they have the money, they know what they're doing, they can go do an arbitration or a mediation at ICSID. But the small and medium enterprises who do a lot of business in the NAFTA region, they don't have that option. So that, is for me a priority, and I hope I'll see it happen in my lifetime. But right now it's on hold, like a lot of things, and we'll just wait and see.
Thank you, Lorraine. That concludes our rounds of questions. We wanted to take a few moments for Q&A. I hear we don't have Q&A questions from our online participants, but we'd love it in the room. Look at that energy. I can only encourage you. We have so much experience and insights on this panel. This is your time.
So thank you for a very interesting panel. We talked about whether the arbitrator and the mediator should be the same person. What about counsel? We've all had clients who wanted to bring in different counsel for settlement, thinking that their advocates were kind of irrevocably tainted with thinking about the dispute too much. I'd love to hear the panel's view on that question.
Very good.
Can I just ask, I had the same question, and also from the perspective of the sort of the thinking of counsel. We have all, in arbitration, we have all heard the notion that arbitration is not U.S. litigation. So when you have a U.S. litigator as an arbitration practitioner, things change. So would that be similar to when you have somebody used to arbitration? Can he or she not necessarily be the right counsel for mediation?
Frauke, can I make a comment?
Sure.
I may be the outlier here, but I think it's a very slippery slope for somebody to act as a mediator and arbitrator. I think there are huge conflicts of interest, and I personally would never do it. JAMS has a unique mechanism called the mediator in reserve, who is chosen at the beginning of a case, and they don't know who the arbitrator is. They just know they're a mediator, may be called as a mediator on the case, and they're up to speed. And if the parties decide they want to mediate, that person, who in my mind doesn't have the conflicts the presiding arbitrator would have, is ready to go. And I think that's an innovative strategy that some of the other institutions might want to look at. But personally, I would never go from being a mediator to an arbitrator, because you can't unring that bell. You can't unknow what you learned in the mediation. And a lot of that would not be permissible, a discovery disclosure in an arbitration. So I just think it's a very slippery slope, as I said.
Yeah. Thank you, Lorraine. I think the question was also addressed to counsel, right? And so, Bill, do you want to start with that from online, and then we'll see here if our panelists have something?
Thank you. So just to make a brief point about it, it seems to me that those who are charged with making decisions, with settlement decisions within a mediation, have got a tough job. There are pressures from all sides. There's pressures across the table from whoever you're against, as it were. There's often pressures from within your own team. There'll be hawks and doves. There'll be other considerations and so on. So what one is really after, I think, is a forum where those who have to make those decisions have as much clarity and sometimes as much simplicity over decision-making as they can. I don't see anything wrong with the principle of bringing in a fresh mind to, let's say, advise on settlement separately from those who are advising on the contest, although I can see the difficulty, because if you're immersed in the contest itself, you'll have a slightly different perspective. But my heart always goes out to those who in mediations who are charged with actually making the judgment calls. A tough place to be, and frankly, anything we can do that helps them make those difficult decisions, I think, is important.
Ximena, you have thoughts?
Yes. So my short answer would be yes. I think mediation is an art form. It's not only about the knowledge and knowing what to do, but it's like actually being able to create these skills of seeing beyond what is said in the room and trying to get them to understand each other when they don't want to and bring them together. So if the counsel has, of course, a lot of background in the investor state and is willing to let go of the counsel hat and have this neutral view of both sides, even though they might be very crazy, are right. And they are right at the same time, even though that doesn't make much sense, how to create something from that moment. So I love a quote from Thomas Well that used to say that an ideal mediator should be a lawyer, a commercial manager, an organizational expert, a professional negotiator, a psychologist, a politologist, a psychoanalyst, an accountant, an engineer, and a diplomat. So it does need, to have a different mindset and be willing to serve your parties into finding or helping them finding the right solution. So, but yes. So
I think you just described my wife there, actually. But I think the simple answer is yes, you adjust your, for example, if you're dealing with arbitration, it has an investment element. That's obviously very different from the commercial. So you tool up as you need, but also I think it's worth bearing in mind, it's a team approach. Even the client as well might need different people involved in the mediation aspect as opposed to the arbitration. And often, there are internal agendas there as well. So I think one has just got to be sensitive. The reality of it is there are very few who can do it all because the way they have developed. There are a few people out there, but not many. But I think it's no harm tooling up and as you need.
It's a significant skill set and tools and experience, certainly, to facilitate mediation. We had other questions in the.
Let me just add that all of the examples that I gave and others that I didn't mention were all scenarios that involved dispute counsel with participation of transactional counsel where relevant. And so it's part of being a good lawyer and part of being an effective law firm. And one of the benefits of being in a more full service law firm, that you bring in those right combinations. For example, I had a very large, complex mining sector mediation, and I had a transactional lawyer with experience in the mining sector who participated. But at the same time, the transactional lawyers may not be familiar with the procedural and advocacy aspects that are part of it. And so I think that's part and parcel of having effective counsel. So pick your lawyers wisely.
And identifying, all your priorities and interests, and you may need a broader team to make these, what we hope for, wise decisions. In the room, yeah, Margaret is handing over the mic.
Thank you. Hi, I'm Mark. I'm an LLM candidate at Georgetown Law. So over the years, we have seen that the phenomenon of third-party funding has been gaining attention. Proof of that, obviously, is the incorporation of this third-party funding clause in the ICSID rules themselves, 2022. And so my question to you really is, what do you think the impact of having claimant using third-party funding in investment arbitration can be for reaching settlement? So because to me, it seems that the funder would, in principle, not be interested in reaching settlement. So the funder just wants to go to the award. That would be just one idea that you could have, certainly. So I'm curious to know your
Very briefly, in principle, I think you're right. It's all about money. They want to get a return on the money as quickly as possible. So generally, they're not there to stand in the way. But it's all you need to be very careful how the third-party agreement is drafted. And there have been tensions and there have been cases where there have been fallout, where the funders are the ones blocking the settlement because it wasn't what they had anticipated. But generally, so it's a really interesting issue. I think but a lot will be, I think, mitigated by the fact that we have clear drafting and what the roles are. But generally speaking, I think they are indeed, as I understand the investment, they're looking to invest money over a period of time. And obviously, the longer it's tied up, the higher the return they want to be getting. So it's all about turning over the money as quickly as possible.
Jonathan, you want to add something?
I agree with Joe.
Okay. Thank you. Yeah, I've heard both sides. I have heard funders who were very interested actually in settlements and early, and what you described. Weird.
Just to pick up on what you just said, yes, I've had funders be driving the settlement. They want to get out. And other times the investment, so it depends very much on the agreement and the circumstances. Right? Here's my question as a mediator. What would the very common concept in US-based and certain international arbitrations of making a mediator's proposal, how would that go over in the context of investor state cases? Bill, I was very interested in hearing how carefully you framed your support for the settlement. And so perhaps I would direct that question to you. The mediator's proposal consists of not taking anybody's side, but just saying, based upon what I've heard, I think that this proposal, be it a renegotiation of a deal or a number, is what both parties can live with very unhappily.
Yeah, thank you. Forgive me, I can't see you, but whoever you are, thank you for asking.
Anna Weiner, hi, how are you?
First of all, I would say I think mediator proposals appear, at least from my friends and colleagues practicing on your side of the pond, to be a much more common and popular practice over there than they are in my neck of the woods. And secondly, I think it's a lot about terminology. I mean, to me, the notion of a proposal is something semi-formal. I think there's so far that you can go as a mediator by discussing what if such and such was offered, would that work? What if the proposal revolved around this structure or these terms or something else? I personally wouldn't call that a mediator's proposal. Others might, I suppose. So I think it's partly a question of terminology. But I know whenever I meet up with US colleagues in particular, and Canadians as well, but I think to a lesser degree, the topic of mediator proposals comes up a lot. And as far as I can work out, it's a much more popular and commonly used approach on your side of the pond.
Can I compliment it a little bit? So I've seen the mediator's proposal. I was trained here in JAM, so I love, the whole model of mediation here. But going back into our cultures, as Bill mentioned, it's not that used. But specifically in investor estate, when you have an estate that is a party, it needs a rationale behind it. So the negotiation will probably not be a distributive bargaining at all. You're going to be looking into the facts and the law and figuring out what the public officers will be comfortable with. So in that sense, you can come up with, ideas, and I sent a lot of ideas, so they never, feel that I'm proposing anything. But a proposal, as this number that they would want probably be.
Not necessarily a number.
Okay.
I've made a mediator proposal that was the ninth draft of settlement.
But maybe, yeah, as long as it has a rationale behind it.
Yes, I understand that point, and that is definitely a distinguishing factor.
Yeah.
I was going to say, I think the principle certainly exists in ISDS dispute resolution, but it's under a different hat. Normally it's conciliation. ICSID is where you have recommendations. The commission can make recommendations. So as a matter of principle, I see no reason why it couldn't be brought into the mediation, but then there's a danger you may no longer be following a mediation model. It depends how formalistic one wants to be about all of this. And I think it's a question of just cultural experience. Bill's right that we don't see it so much on our side. Although I don't know, Bill is, I'm seeing a growing pressure, getting asked more often on that side. Yeah.
It was a interesting discussion in the context of our consultation with the member states on the mediation rules. We have a provision that the mediator may make recommendations with the parties' agreement. So absent that, that would not be the role. And that is one of the differences to conciliation, as Joe pointed out. Thank you for these active questions. And before we conclude, let me give 30 seconds to each of our panelists. If you could leave the audience with one single idea or piece of advice regarding investment mediation, what would it be? Jonathan, why don't we start with you?
Alignment. You need to align many different people, not forever, but only for long enough to get through a day or a week where you can get all of these different sort of pieces of the Venn diagram aligned for the moment where you can get a deal done. There's a movie that came out about 10 years ago where two fund managers in New York, they have lunch, and one guy is going to sell his fund to the other guy. They whip out a napkin and they write, 500 million on it. They each initial it. Easy. They each would have taken a little more, a little less, but deal done. It's exactly the opposite in these kinds of scenarios. And so you've got to figure out what each of these diverse players on each side need so that you can get alignment to get a deal done. And that involves baby steps to get people comfortable agreeing. And it involves accepting that you don't have to be friends forever. You just have to get this deal done.
Thank you. Joe, over to you.
Well, use it, do it. I think there's a perception issue with mediation generally that it's not really suitable or appropriate for big, serious claims. They don't get much bigger, more serious than investor state claims. And I would argue the complete opposite is true. You have the flexibility to come out, as already been mentioned several times, with a solution that arbitration litigation could never touch. So I think but as Bill mentioned, it's complicated, but none of it's really rocket science. There's some real sensitivities there. The big elephant in the room is this transparency issue, confidentiality, but they are surmountable. And organizations such as the Energy Charter Treaty, ICSID, UNCITRAL have gone to great lengths to prepare all kinds of briefing documents to help governments in particular prepare themselves to deal with these issues. So it's certainly possible to overcome, and it's something that needs to be both from the state's point of view, because ultimately, if they're going to be paying, this is taxpayers' money, there should be a better way of resolving these things. And with that, I can take a hint.
30 seconds for you, Ximena.
Thank you.
Not 5 minutes, that at all.
Thank you. Well, my thing to leave you all is that this is happening. Mediation is sprouting, I think, all over the world. It's not anymore this, weird idea that will never occur in investor state. I think once an investor knows how much money they save and how much money they can actually make by, regaining the relationship, and the state understands that they have the control and the political control and that they can create something that makes sense, this will become a policy. So it will happen a lot.
Okay, one piece of advice, Lorraine, from you, 30 seconds.
Just based on the last 20 years, innovation is going to be key. 20 years ago, the ICC was not in the mediation or ADR business, and they very much are now. So I think there's going to be a lot of innovation. I think this is going to be more than acceptable in 20 years or less. And I think that we just have to be open to new tweaks and new products. And like I said, I'm very optimistic for the future.
Thank you. Bill, 30 seconds to you.
Thank you. Look, it's interesting in gatherings when there are seminars on IS mediation and so on, there are so many theoretical problems. Actually, in reality, the vast majority of these can be circumvented with a bit of hard work and common sense. And I think, as I said earlier, and as Joe just mentioned as well, it's no point going in expecting it to be easy. There'll be lumps and bumps. These things always are. So as long as you don't expect it to be easy and you're willing to work at it and bring, I suppose, to work from first principles as well. I think if anything doesn't work, it would be the cookie cutter approach. I mean, I don't think it works anyway in mediation, but even more does it not work in IS mediation. So really some thoughtfulness and flexibility and trying to work from first principles, I find is by far the best.
Thank you. Thank you to my fellow panelists. Thank you for Jens for hosting us here. And thank you to Washington Arbitration Week for putting this on. Let me give it a